a preliminary injunction in place with a lot of people heading out to their local gun stores to buy semi-automatic rifles, handguns, or shotguns, and also magazines over a certain capacity. And that injunction in place still to this date after being issued late Friday last week. Back at it, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. In a remote location, I'm actually in a home-built studio here that I threw together in about a day and worked out all the bugs, so I appreciate everybody chiming in. But a lot to get to. Of course, we heard Luis Valdez from Gun Owners of America talking about what this means for gun owners in Illinois when it comes to this preliminary injunction being put in place. Here is Luis Valdez.
This is a tremendous step in restoring Illinois' gun owners' Second Amendment rights, first and foremost. You had the governor wanting to pass a draconian piece of legislation to strip them of their Second Amendment rights, and here you had a federal court rule against the governor, rule against the anti-gun forces within the state of Illinois, and clearly state that we, the people, have the right to keep and bear arms.
So Valdez obviously making the point that the ban is not enforceable at this moment. And as we talked about and as you've read about, now the state appeals to the Seventh Circuit Court of Appeals with a question to put a stay on enjoining the state from enforcing the gun ban. And over the weekend, the past few days, a lot of images of gun stores across Illinois that have a lot of customers waiting in line to purchase certain types of semi-automatic weapons and magazines of a certain capacity. This after having months upon months since January 10th, the inability to purchase those items. And of course, you do that at a federally licensed gun store. But in Illinois, they also have to have a state license to operate. So some gun stores might be apprehensive about actually recognizing that preliminary injunction that's in place. So we may hear a little bit about that apprehension later on. We're going to talk with Todd Vandermeide. But that's from the Southern District of Illinois, where Stephen McGlynn issued that preliminary injunction against the gun ban. And so you have that playing through the courts, but you have local bans that are in place. In Naperville, for instance, Law Weapons and Robert Beavis suing the city of Naperville last year and amending his complaints to also challenge the state's ban. That was decided in February with a Northern District judge siding with Naperville and the state, upholding the weapons ban. And then you had an appeal to the Seventh Circuit Court of Appeals where Beavis et al., they asked the Seventh Circuit Court of Appeals to put a stay or a preliminary injunction on Naperville's ban, which the Seventh Circuit denied that motion. So that asks, some questions as to how the Seventh Circuit's going to react to the Southern District with the preliminary injunction in place. But back to the Naperville case, since that preliminary injunction was denied by the Seventh Circuit Court of Appeals, it's still going to be appealed and go through that appellate process. But the plaintiffs in that case, they filed with the U.S. Supreme Court a motion to have a preliminary injunction in place against Naperville's ban while the case plays out. Here's Hannah Hill from the National Foundation for Gun Rights talking about what this appeal ultimately means and how her clients and the plaintiffs in Naperville and elsewhere where there's local bans are in place are being impacted by all of this.
So we filed essentially an appeal for emergency relief from the Naperville Ordinance and from the Illinois assault weapons ban. So what we're asking the Supreme Court to do is to step in and to give us an immediate suspension of both of these laws. So the legal term for it is an emergency application for injunction pending appellate review. What that essentially means is that we want the Supreme Court to step in and hit the pause button on both of these laws while the Seventh Circuit is considering whether or not to give us a preliminary injunction, which would then suspend the laws for the remainder of the case.
So these cases still very much fluid, moving through the process, being decided in one court one way, being decided in another court another way. You've got a preliminary injunction in place while all of this is being appealed to the Seventh Circuit. and the Naperville case being accepted by the U.S. Supreme Court, Amy Coney Barrett making this decision to accept that pleading from the plaintiffs in Naperville. And if you check out the statement here from the Gun Rights of America and the National Foundation for Gun Rights, you'll see that they announced earlier this week Justice Amy Coney Barrett requested further response from the city of Naperville for their assault weapons ban. And the National Association for Gun Rights with the National Foundation for Gun Rights arguing that the Illinois ban violates the Second Amendment to the Constitution. Hannah Hill lays out some of those arguments.
Get emergency relief. We have to prove three things to the Supreme Court. We have to prove that, one, our Second Amendment claims are likely to prevail. That is to say, we've got a case and that we can win it under the Constitution and under the Supreme Court's precedent. And that is absolutely the case. So this is essentially a slam dunk. Heller has ruled, the Supreme Court ruled in its Heller ruling in 2008 that the Second Amendment protects the right of citizens to own weapons in common use, like AR-15s, for self-defense. So applying that and applying last year's Bruin ruling, there is no way that this case can fail under the Constitution. So where this case gets complicated is when a judge or a court tries to wiggle their way around the very clear precedent of the Supreme Court. So as far as that test goes, what we're asking the Supreme Court to do is simply to uphold their own rulings. So yes, we absolutely are likely to prevail on our Second Amendment claims. Second test is that we have to prove that denying us relief would lead to irreparable injury, as you mentioned. And that there are two sides to that coin. The first side is that a right delayed is a right denied. As the Supreme Court itself has said, the Second Amendment is not a second-class right subject to a completely different body of guarantees. Subject to a completely different set of rules as other Bill of Rights guarantees, like the right to free speech and the right to freedom of religion, et cetera, et cetera. But so essentially, typically the courts will consider that if you can prove that a law is trampling on a constitutional right, you are creating an irreparable injury every day that unconstitutional law is in effect. But there's also more. Our plaintiff, Robert Beavis, who owns Law Weapons and Supply in Naperville, is facing the loss of his business as long as the Naperville AR-15 sale ban is in place and as long as the state assault weapons ban is in place. So we've been trying to get both of these laws suspended for months, and month after month, he is facing the loss of the majority of his business. He's taken financial hit after financial hit. And if he doesn't get relief soon, he is facing the loss of his business simply because his local and state government decided that they did not like his business. They did not like a constitutionally protected product, and they don't like the people who choose to buy and acquire them for lawful purposes. So that is how we're showing irreparable injury if we don't get this relief. And then the third test is that granting relief would not harm the public interest. And that one's a slam dunk because protecting constitutional rights is not only does that not harm the public interest, it is always in the public interest to uphold Bill of Rights guarantees. And so that one is very, very easily proven. And that's essentially what our legal team is telling the court. So it's a very straightforward filing. It is a legal long shot because the Supreme Court doesn't often like to weigh in before the lower court processes are finished. But we are hopeful that since we can make such a strong showing on all three of these tests, we are hopeful that we will be the exception to the rule and that the Supreme Court will step in to uphold the Second Amendment in Illinois.
So the Supreme Court did accept the motion and has now requested more information from Naperville, which, this is just the first part of this process. While it still plays out in the Seventh Circuit Court of Appeals, the Naperville plaintiffs are simply asking the U.S. Supreme Court to step in and issue an injunction on Naperville's gun ban. Now, again, the Illinois gun ban, not enforceable at this moment while it plays out in the courts after Stephen McGlynn issued that preliminary injunction, and a lot of gun stores across the state seeing a boost in sales because of it. People who weren't able to purchase a semi-automatic rifle or a magazine of 30 rounds, they went to the gun stores and purchased those items that they may have put off purchasing because of the gun ban. But here we are. Now, with the local ban still very much up in the air and the questions around how those are going to play out in the courts, we'll be watching that very closely here. A lot of moving pieces, and these are just the federal cases, not even the state level cases, which later on this month, on the 16th of May, the Illinois Supreme Court is going to be hearing Dan Calkins' challenge to Illinois' gun ban on the grounds that it violates the issue of equal protections, essentially saying you can't carve out constitutional rights for one set of people and not allow it to be a right for others. So that's the state level case. And we'll hear those oral arguments and how they go about hearing those. But also with the federal cases, that's challenging the Second Amendment grounds, and we'll see all that play out as well. Tons of moving pieces, and we've got more to get to on all of that, including late next hour. We'll talk with Todd Vandermeide, gun rights advocate, former NRA lobbyist, host of the YouTube channel Freedom's Steel. We'll get his reaction and some of the other questions that there are still overarching when it comes to the state's gun ban being enjoined from being enforced, and how some gun stores may be reacting to that.